Janet Jackson and Mr. Al Mana appears to be getting a divorce. So let's talk a little bit more about Muslim divorce, shall we? In the talaq divorce, the husband pronounces the phrase, I divorce you, to his wife. A man may divorce his wife 3 times, taking her back after the first two, reconciling. After the third talaq, they can't get back together until she marries someone else. Divorce in Islam, and this comes from the Wikipedia, the free encyclopedia. Now, I find it very interesting that he can divorce his wife 3 times, but after the third time, she cannot go back to him unless she marries someone else. Divorce is Divorce in Islam can take a variety of forms, some initiated by the husband and some initiated by the wife. The main traditional legal categories are talqa, Talaq, khul, Khul, judicial divorce, Judicial divorce, and oath. The theory and practice of divorce in the Islamic would have varied according to time and place. Historically, the rule of divorce was governed by shura as interpreted by traditional Islamic jurisprudence, and they differ depending on the legal school. His historical practice sometimes diverge from legal theory. In modern times, as personal status family laws were codified, they generally remain within the orbits of Islamic law, but control over the norm of divorce shift from traditional jurists to the state. Quranic principles. According to the Quran, marriage is intended to be unbound in time, as indicated by its characterization as a firm bond and by the rules governing divorce. The relationship between spouses should ideally be based on love. An important decision concerning both spouses should be made by mutual consent. When marital harmony cannot be attained, the Quran allows and even advises the spouse to bring the marriage to an end. Although this decision is not to be taken lightly, and the community is called upon to intervene by appointing arbitrators from the two families to attend a reconciliation. The Quran established two future means to avoid hasty divorces. It prescribes two waiting periods of 3 months before the divorce is final in order to give the husband time to reconsider his decision. Moreover, a man who takes an oath not to have sexual intercourse with his wife, which would lead to automatic divorce, is allowed a 4 month period to break his oath. The Quran substantially reformed the gender inequality of divorce practices that existed in pre-Islamic Arab Islamic Arabia, although some patriarchal elements survived and others flourished during later centuries. Before Islam, divorce among the Arabs was governed by unwritten customary laws, which varied according to region and tribes, and its observance depended on the authority of the individual and group involved. In this system, women were particularly vulnerable. The Quranic rule of marriage and divorce provided a fixed set of norms for all Muslims, backed by divine authority and enforced by the community. The early Islamic reform included giving the wife a possibility to initiate divorce, abrogation of the husband's claim to his wife, property, condemnation of divorce without compelling reason, criminalizing unfounded claims of infidelity made by the husband, and institution of financial responsibility of the husband towards his divorced wife. In pre-Islamic times, men kept their wives in a state of limbo by continuously repudiating them and taking them back at will. The Quran limited the number of repudiations to 3, after which the man cannot take his wife back without an intervening marriage to another man. Additionally, the pre-Islamic bride wealth, ma, which was paid by the groom to the bride's family, was transformed into dower, which became property of the wife. Though some scholars believe that the practice of giving at least a part of the ma to the bride began shortly before the advent of Islam. The subject of divorce is addressed in 4 different suras of the Quran, including the general principle, Article 2, 231. If you divorce women and they reach their appointed term, hold them back in amity, or let them go in amity. Do not hold them back out of malice, to be vindicative. Whoso does this does himself. So we have several more that we need to go over because I think we really want to understand, at least I want to understand, um, this divorce business. Janet Jackson opened up a can of worms. Classical Sharia, legal context. Classical Islamic law is derived from the scriptural source of Islam, Quran and Hadith, using various methodology developed by different legal schools. It was historically interpreted by jurists, muftis, who were expected to give a legal opinion, fatwa, free of charge in response to any query. Family disputes were handled in Shara courts, presided over by a judge, Qadi, who had enough legal education to decide some legal questions. Inquiry, or mufti, if faced with a difficult legal issue. The judge was an active member of the local community and were also involved in informal arbitration, which was the preferred method of resolving disputes. In court proceedings, they mediate between the letter of the law and exigencies of the local social and moral concerns, with the overarching aim of ensuring social harmony. Actual legal practice sometimes deviate from precepts of the legal school that was dominated in the area. At times, to women's benefit, at times to their disadvantage. Members of all social classes and their witnesses argue their cases in court without professional legal representation, though members of the upper class generally did so through a representative. Women were commonly involved in litigation, usually as plaintiffs, were assertive in arguing their cases, and they were often treated sympathetically by the judge. According to legal doctrine, a woman's testimony in most areas of law carried half the weight of that of a man, though available evidence suggests that practical efforts of this rule was limited, and the legal standing of women in pre-modern Islam was comparable to or higher than that of their European contemporaries. So again, this to me is saying that Muslim women were not equal, okay? Because in hearing other people talk about Janet Jackson and her husband, they're saying that Janet Jackson got over, and why would her 42-year-old Muslim husband marry an older woman? At 50 years old, they got together when she was in her 40s, her late 40s, 46. She looked great, you know. When it comes to love, it is not about age. It's about how you feel towards that person. And then we're hearing that this man was attracted and admired this black woman, the way she looked, okay? And that's interesting because in his country, their slavery still goes on. They still have black people as slaves. We know that. So he could have had any black woman he wanted, but he chose her. But he could not have her the way he could have another woman. And some people aren't even discussing that. Okay? So was she wrong, Janet Jackson, to have a prenup to make sure that if she was married to him for so many years, she would get what, $400,000? And then if she had a child, she'd get another $100,000. Because I mean, she's supposed to be getting $500,000, $500,000, right? I don't hear anything about child support while the child is being born. After the child is being born, because you know what, money goes too fast today, and the child is here now. So they're both going to make good parents because they started out right. But again, I shouldn't put my 2 cents in it, but I am. I explored when I was younger, in my teens and early 20s, explored becoming a Muslim, and all being all wrapped up just is not who I am. And some women aren't able to wrap themselves up like that. Okay? So I understand what Janet's saying. And then feeling enslaved to the man, because again, the men have all the power. But again, the man is rich, so he had servants. So how much enslaved is she going to be in, besides the fact that she's restricted in her way of life, you know, dressing sexy, going out and socializing when and whatever she wanted. That's hard. Okay? So let's talk about the talq, TALAQ, reprobation, jurisprudence. The term talaq, I think that's how you pronounce it, talaq, is commonly translated as repudiation or simply divorce. I don't know why we can't say it, because, again, it's another religion, different language. In classical Islamic law, it refers to the husband's right to dissolve the marriage by simply announcing to his wife that he repudiates her. It requires neither justification nor court approval. Classical jurists impose certain restrictions on valid repudiation. For example, the declaration must be made in clear terms The husband must be of sound mind and not coerced. The husband's prerogative of repudiation is commonly rationalized with references to the fact that Islamic law of marriage imposes financial obligations only on the husband, including payment of the mahr and providing maintenance. Additionally, classical jurists were of the option that the female nature is wanting in rationality and self control. So again, we don't know. People are saying that Janet did this, but I'm saying she gained so much weight that the husband just don't like the packaging anymore. That happens. We don't really know what is what, but I do know Janet came from a father who was controlling, and then to marry another controlling man. I mean, she's drawn to that because that's all she knows, and she really needs to go for some therapy. I know I had to. Okay, getting back to the talaq is considered in Islam to be reprehensible means of divorce. The initial declaration of the talaq is a revocable repudiation, TALAQRAJAH, which does not determine, which does not terminate the marriage. The husband can revoke the reparation at any time during the waiting period, iddah, which lasts 3 full menstrual cycles. That's 3 months, okay? The waiting period is intended to give the couple an opportunity for reconciliation and also a means to ensure that the wife is not pregnant. Okay, now what if the woman no longer has a period? Okay, I'm just throwing that question out there. All right, because it says it lasts for 3 full menstrual cycles. She has to have a period. Okay, resumptions of sexual relations automatically retracts the repudiation. The wife retains all her rights during the waiting period. The divorce becomes final when the waiting period expires. This is called a minor divorce. Banuna Sucha, and the couple can remarry. So I wonder, did this happen prior to Janet Jackson getting pregnant? We don't know. See, there's a lot we don't know. If the husband repudiates his wife for the third time, it triggers a major divorce, Bayuna Kubra, after which the couple cannot remarry without an intervening consummated marriage to another man. This is known as nikah halala. Some legal schools held that a triple talqiyah performed in a single meeting constitutes a major divorce, while others classify it as a minor divorce. Upon talaq, the wife is entitled to the full payment of mahr if it had not already been paid. The husband is obligated to financially support her until the end of the waiting period of the delivery of her child. There you go. If she is pregnant. In addition, she has a right to child support and any past due maintenance, which Islamic law requires to be paid regularly in the course of the marriage. And this is what I think happened last year. I think she ends up getting pregnant one way or the other, whether it was in vitro insemination. She ended up getting pregnant, which stopped everything. And so here we go today with them getting a divorce right now. Because, again, this really seemed kind of strange after we're in April now. So from January 3rd, when the baby was born, until April, 3 months later, April, January, I'm not counting January, February, March, April, 3 months later, it does sound suspicious. Okay? Practice. Women often enter marriage with substantial capital in the form of ma and the tusa provided by their family, which they were not obligated to spend on family expenses, and they frequently loaned money to their husband. Okay, Janet had her own money, but again, she's not worth as much as he's worth 4 times her wealth. Okay, because of this and the financial obligation incurred, talak could be a very costly and in many cases financially ruinous enterprise for the husband. Many repudiated women use the divorce payment to buy their ex-husband's shares in the family house. In the historical record, talak appeared to have been less common than coal or coal. Available evidence from Mamluk Egypt indicates that talaq was not the principal means of divorce. Talaq was considered to be disastrous for the woman because it deprived her of long-term protection and financial support, preventing her from remarrying. Since this would cause her to lose child custody, this led to repudiation without good reason being considered socially improper. Studies of the Ottoman Levant showed that women could invalidate a declaration of talaq by stating that the husband had shown signs of diminished rationality when he made it, while others used husband's unrevoked declaration of talaq to obtain divorce at a later date if they could prove that he made it. Tawhid, Tafwid, delegated talaq. The husband can delegate the right of repudiation to his wife. This delegation can be made at the time of drawing up the marriage contract, nikah, or during the marriage, with or without conditions. Many women included such terms in their marriage contract. Commonly, the contract gave the woman the right to repudiate herself if the husband married a second wife. Delegated repudiation is called talaq al tafawut or tafwid. Mutual divorce. Jurisprudence. Is a contractual type of divorce that is initiated by the wife. It is justified on the authority of verse 2, 228. It is not licit for you to take back anything you have given them unless the two of them fear that they cannot conform to the bounds of God. No blame attached to them both. If the woman gives back that with which she set herself free, these are the bounds set by God. Do not transgress them. It is further based on a hadith in which Muhammad instructed a man to agree to his wife's wish of divorce if she gives back a garden received from him as part of her month. A quarrel is concluded when the couple agrees to a divorce in exchange for monetary compensation paid by the wife, which cannot exceed the value of the month she had received, and is generally a smaller sum or involve forfeiting the still unpaid portion, Hanafis, and Malikas do not require compensation paid by the wife. The divorce is final and irrevocable, effective when the contract is concluded. The couple cannot reconciliate or reconcile during the waiting period, defined as in the case of talaq, but the husband is required to pay maintenance during its term, unless the requirement is waived by the contract. As in the case of talaq, remarriage is possible until a quarrel is concluded for a third time. If the husband pressures his wife to agree to quarrel instead of renouncing talaq, which would let him avoid attending financial responsibility, the divorce is considered to be invalid. Like talaq, quarrel takes place out of court. So you're saying to me that their agreement can keep them out of court. Interesting. Otherwise, this is really boring. Relative frequency of quarrel has been noted in studies of Istanbul, Anatolia, Syria, Muslim, Cyprus, Egypt, and Palestine. In studies of Malik Egypt and the Balkans under Ottoman rule, quarrel was shown to have been the principal means of divorce. Women employed a number of strategies to force a settlement from their husbands. Some neglected their marital and household duties, making family life impossible for the husband. Others demanded immediate payment of the deferred mahr, knowing that the husband had no means to comply and would be jailed if he failed to do so. In some cases, the qua contract involved no compensation from the wife, while in other cases, women would waive all of their husband's financial obligations. According to study of the Ottoman Levant, various court procedures were put in place to ensure that a call was not actually a talaq. Justicial divorce, jurisprudence. A marriage can also be dissolved by means of judicial divorce. Either spouse can petition a quadi court to obtain judicial divorce, but they must have compelling grounds for dissolving the marriage. The court starts the process by appointing an arbitrator from each of their families in order to seek a mediated reconciliation. If this effort fails, the court adjudicates the dispute by apportioning fault for the breakdown of the marriage with the associated financial consequences. Examples of fault are cruelty, husband's failure to provide maintenance or pay the immediate installment of mahr, infidelity, desertion, moral or social incompatibility, certain ailments, and imprisonment harmful to the marriage. Now here we know Janet Jackson had not talked. She talked about social incompatibility because her former lifestyle, which she believed wasn't going to affect her by changing her religious beliefs to Muslim, but it has. It caused her to almost commit suicide, is what she's saying. So, hey, this fits here. Judicial divorce can also be sought over violations of terms, stipulation in the marriage contract. Different legal schools recognize different subsets of these grounds for divorce. The Maliki school which recognize the widest range of grounds for divorce, also stipulate a category of harm, the Darak or Dark Arc, which gave the judge significant discretion of interpretation. We got a few more to go, my brothers and sisters. Practice. In some areas under Ottoman rule, it was hardly possible for women to obtain divorce except through call due to the restriction imposed by the prevailing Hanafi school. Though some exceptions have been found, the most serious problem was abandonment, which was not recognized as grounds for judicial divorce. To address this, in some cases, a man settling out for travel would leave his wife a letter authorizing talcus if he did not return within a specific period of time. In other cases, Hanafi judges invited a Maliki or Hanbali colleague to pronounce divorce, or the woman herself took the initiative to seek out a judge from one of these schools. The same approach was used to effect the divorce in cases of prevent failure to provide maintenance. In the Ottoman Balkans, a woman could file for divorce on the grounds that her husband was not a good Muslim. Wow. So, all of this is really important because, again, Janet Jackson had to go and take classes to be a Muslim wife. She was in training and she had to learn about the law as far as getting married and getting out of the marriage. Okay? But I don't agree with men who take things on one side. People may discriminate against me because I always try to get you to understand there's two ways, two sides to a story. And although Janet is claiming, that, she's not really saying her husband was abusive. The person who's telling the story said he had periods where what they would consider abusive tendencies. Okay? Janet's not claiming that. Janet is claiming that she cannot live in the Muslim lifestyle. Living in an exclusive, she is an extrovert. She's used to paparazzi and the fame and the fortune and the cameras, where her husband is inclusive and he likes to be in a private setting. And at first, she liked that, you know, but now it's taken on a lot for her because, again, she'd be home and she's under guard, like she's a prisoner in her own house. Come on now. I live in Queens and I refuse to put bars on my windows and doors because I don't want to feel like a prisoner. My whole thing is I want to, if God wanted me to be in prison, He would take me to jail and I would have bars. But for me to have to live in my own house and bar my windows and my doors, you know, that's just not for me. And that's me personally. Everybody doesn't feel like I feel. How do you feel about being barred? So I want to jump here. I want to jump. And I'm gonna tell you what I'm gonna skip. Or we were on judicial divorce, jurisprudence practice. They have the oath jurisprudence. The husband can end marriage through three types of oath: the oath of continuance, the denial of paternity, and conditional. The first two types were pre-Islamic practices confirmed by the Quran, which also makes clear that I or Izhar is reprehensible despite being legally valid. Ilah is an oath whereby the husband vows to refrain from sexual relationship with his wife for at least 4 months. If he fulfills his oath, the marriage is dissolved. If he breaks it, the marriage continues. Okay? And we're just going to move on. I know that interests us, the sex part of this, but you can pick up the article yourself. It's online. I want to talk about the other sequence of divorce. Islamic law does not recognize the concept of communal property, and divisions of property is based on its attribution to either spouse. The wife obtains custody of the children until their majority, whose definition varies according to the legal school, while the father retains guardianship. Okay, so now we know why the baby is with Janet. Child custody practices under Ottoman rule appear to have followed the rule of Hanafi jurisprudence, although in Ottoman Egypt, children generally stay with their divorced mother beyond the prescribed age. A divorced woman could keep custody of the children unless she remarried and her husband claimed custody, in which case it generally passed to one of her female relatives. Under the Maluk, women could waive the right to child support in order to obtain extended custody. So, see, we just learned something else. And then we have the dowry, okay, which is the mahr, Mahr, in divorce. The mahr is a nuptial gift made by groom to the bride at the time of marriage. Upon receipt, it becomes her sole property with complete freedom of use and disposal. The marriage contract is not valid without the mahr. The amount of the mahr generally depends on the socioeconomic status of the bride. The payment of a portion of the mahr was commonly deferred and served as a deterrent to the exercise of the right of unilateral divorce by the husband. Although classical jurists disagreed about the permeability and manners of deferring payments of the mahr. Islamic jurisprudence has clear guidance on handling a mahr in the case of divorce, depending on who asks for the divorce and whether or not the intercourse occurred. If the husband asks for a divorce and intercourse has occurred, he pays full mahr. If the husband asks for divorce and the intercourse has not occurred, the husband pays half the dowry. If the wife asks for divorce and intercourse has occurred, the husband pays half the mahr. And if the wife asks for divorce and is still and intercourse has not occurred, then no mahr is required to be paid by the husband. Okay? I mean, that part is very interesting. Modern era legal transformation. In the modern era, Sharia based laws were widely replaced by statutes based on European models, and its classical rules were largely retained only in personal status, family law. Different explanations have been proposed for this phenomenon. Several scholars have argued that because these laws are more extensively specific in the Quran and Hadith than others, it has been difficult for believers to accept deviating from these rules. Okay, and I'm just going to go down. Martin, okay, method of reform. Changing social conditions have led to increasing dissatisfaction with the traditional Islamic law of divorce since the early 20th century. Various reforms have been undertaken in an attempt to restrict the husband's right of unilateral repudiation and give women greater ability to initiate divorce. These reforms have utilized a number of methods, of which the most important are. So this is why they're saying women are, idolizing Janet because she's done something good for the Muslim women, okay, by seeking this divorce. And basically with her fame, she's shedding light on this situation. Okay? And basically that's what they're happy about. Okay. So I'm going to end that with that. Prevalence, according to Yosa Rapport, in the 15th century, the rate of divorce was higher than it is today in the modern Middle East, which has generally low rates of divorce. In 15th century Egypt, Al-Saqi recorded the marital history of 500 women, the largest sample on marriage in the Middle Age, and found that at least a third of all women in the Mamluk Sultanate of Egypt and Syria married more than once, with many marrying 3 or more times, according to Al-Saqi. As many as 3 out of 10 marriages in 15th century Cairo ended in divorce. In the early 20th century, some villages in western Java and the Malay Peninsula had divorce rates as high as 70%. And brothers and sisters, therefore, we conclude. Thank you for listening.